Good afternoon, everyone. Afternoon, right? Yes, true. So, good afternoon. Thank you all for coming. We're going to give it another minute or so, just so that we get people who are kind of still falling to take a seat. And we should be getting started shortly. Thank you. All right. Well, thank you all again so much for being here. And thank you for participating for the commercial leases for small business owners. With that being said, my name is Cecilio Scutia. I am the program manager for the Building Business Guide program. So before we jump into the actual workshop, the actual meat and potatoes of the presentation, I'll give you a brief overview of what we do and how we can help your small business. So what is Building Business Bag for BBB? So in a nutshell, Building Business Bag is a informational hub where businesses can find resource information on grants, loans, tax credits. If you can think about it, we more than likely either have the information or are looking into it. And the way that we access or we're able to do this is by utilizing free workshops and our partnerships. So we've committed to doing 15 workshops a year on various topics from the dimension of tax credits to commercial leasing and so much more. Last year, we also did one workshop called Solución Americana with su item, or how you can achieve the American dream with your item. And then we also offer free technical assistance. So whether it's applying online for their city permits or things like that, we're able to help you out with that information. Um, Apart from offering the our services within Monterey County, we do have an emphasis on certain underserved communities. So women-owned business, minority-owned business, LGBTQ plus owned businesses, as well as those businesses operating in unincorporated areas of the county. All of our services are completely free, no charge to you, all because the county was able to set aside some funding from ARPA on helping businesses recover from COVID-19 pandemic. And then with that being said, I will pass it on to Tara Clemens and Logan Walter from Defendant Killer. Okay.
I'll say. We'll introduce ourselves very quickly, and then we've divided today's talk into two topics, two sides. And so I'll take the first part, and then Logan's going to take the second. So my name is Tara Clements. I am an attorney at Fenton and Keller. Most of my practice is focused on transactional work as well as trusts and estates. Do a lot of commercial transactions, including review and negotiation of mostly commercial leases, again, of all sorts.
And I'm Logan Walter. I'm a business transaction and corporate attorney by trade. I also do trust and estate work. And I also have a background in mergers and acquisitions and sales of businesses as well. So to say that leases make up a portion of our job is an understatement, especially in the business arena.
Absolutely. So the area of commercial leases is pretty complex. It's very fact specific. You're going to hear us say probably more often than you would like that a lot of what we're going to talk about, how it might apply to you, is going to depend on your specific facts and circumstances. And so what we're offering today is just kind of a general overview of some common issues that come up with regard to commercial leases. It's certainly not exhaustive. And so before acting on anything that you may hear today, we do recommend that you talk to an attorney about your specific facts and situation.
Absolutely.
Okay,
I'll let you take it and then I'll.
all right. We'll see if I can be smarter than the technology. All right, so today's topics, as I mentioned, we're just going to hit some of the highlights. So what is a commercial lease? Why does it matter? Who are the parties to the lease or the parties that might be affected by a lease? Where, that is the space and its use, when, time and money, and how will the lease end? So all of these things are things that should be considered before you even get into a lease, whether you're a landlord or a tenant. So first of all, what is a commercial lease? A lease is an agreement. It's a binding contract between a landlord and a tenant, setting forth the terms and conditions of the rental agreement for the premises that are being leased to the tenant. So that's the most simple, straightforward definition of it. There's a lot that falls under that definition. A lease can be distinguished from a license. So for example, you may be aware of situations like the WeWork offices or shared space arrangements. The agreements that are at issue there are often licenses, whether they're called that or just their substance. The reason it matters, the difference between a license and a lease, comparing and contrast, is because a lease is going to give the tenant rights in the real property. A license does not. Where that matters is, like, for example, at the end of the lease, before a landlord can terminate a lease, let's say the tenant defaults, they're not paying the rent, okay? But in order for the landlord to terminate or to have the tenant move out, they have to go through, my mind just blanked. These are eviction package. Thank you. Yes, I'm like, it starts with an E. Yes, exactly. They have to go through the eviction process under California law. Okay, exactly, the unlawful detainer. If you are merely a licensee for shared workspace, that is not required. It's going to be dependent on whatever's in the agreement, which oftentimes just means that the person who manages the space only has to give you 30 days notice. Okay, so that's one of the main differences between the two. So leases, as I mentioned, real property interest versus license. And then also a lease is going to give you certain rights. There's a couple of things to be aware of, though. Oftentimes at the beginning of negotiating a commercial lease, the parties may enter into what's called a letter of intent. That is, the material terms are agreed upon, where the space is, how much, for how long. There's very basic material terms that the parties agree to, but they want to keep talking and negotiating the rest of the terms. So they will often put those into a letter of intent. Usually a letter of intent is non-binding on the parties and it cannot be enforced as a lease, but you want to make really clear that that is the intent for that letter. If it's not clear, that is, it doesn't say this is non-binding, or the conduct of the parties would support that they were operating as if it was a lease. If one party is disgruntled or wants to enforce it as a lease later, the court may recognize it as lease. So that's one thing to just be aware of. Another thing to be aware of is there are certain disclosures that are required to be given by landlords. Specifically, if the building was constructed prior to 1979, whether there is or may be asbestos. There's a few exceptions to that under the code, but that's generally one of the disclosures that needs to be made. The other is if the landlord is aware of the presence of mold under certain conditions. Another thing to be aware of is that sometimes people are excited, new business is starting, maybe there's already some sort of relationship between a landlord and a tenant, and they just enter into an oral agreement. The law is for a lease that is to last longer than 1 year, that needs to be in writing and it needs to be signed by the party that you're trying to enforce that agreement against. So the safest way to do it is when people sign a written document setting out the terms of the lease. So the absolute essential elements for a lease is a definite agreement as to the extent and boundary of the leased property, usually described in the lease as the premises. A definite and agreed upon term, that is how long the lease is to last. And then a definite and agreed upon price of rental, including the time and manner of payment, that is how often are payments to be made and where are those payments to be made. And again, if those terms are set out in a letter of intent and that letter is not clear, this is non-binding, then that letter could be enforced later on as the lease itself. One other thing that I want to bring out is the difference between a commercial lease and a residential lease. So some of us may be familiar with residential lease agreements. There are certain very protective provisions in California law for tenants in residential leases. That's not the same for a tenant in a commercial lease. I'll give you a couple of examples. There is an implied warranty of habitability or suitability that will apply in a residential lease. That is, basically, this property is suitable for someone to reside, to live. There is no similar warranty for commercial property. So it's incumbent upon the tenant to make sure that they negotiate those provisions that they need or do their due diligence to make sure that the property has what they need to operate the business that's going to run there. There's also no statutory duty for a landlord to repair its lease premises. So again, to the extent that repairs or maintenance are essential to the tenant, you want to make sure that those are covered in your lease. There is an implied covenant of quiet enjoyment. And that is, the tenant has the expectation that they can enjoy the property and not be disturbed from that. Usually where that comes up is where you're negotiating how often can the landlord inspect the property, what notices need to be given prior to that inspection. They can't just come and go as the landlord decides to show up.
And you were speaking commercial and residential in that case, where you was focusing on.
That last one is applicable. All three are applicable in residential.
Okay.
But the last one is one that the law recognizes for commercial leases. The first two are not. Those protections or considerations would need to be included in the lease. Yes.
With those an example of situations where they're making like livability and where those things were not mentioned in the lease and that was a problem for the tenant or business owner.
Well, it's not, it doesn't apply to commercial leases. That livability doesn't apply.
So like a situation where probably with a tenant, I would want to add that as like what are the kind of situations where like I own a bakery and like what is the thing that I should write in the lease other than I am planning to operate a bakery?
Right, so, okay, so for a bakery, you're probably gonna want running water. You're gonna want heat, you're gonna want certain things.
Okay.
And who is responsible for maintaining, whether it's maintenance, repair, providing utilities? Those are the types of things that you're going to want to make sure that your lease covers. So,
Do you prefer to ask questions as we go, or do you want to leave questions for the end, or because I don't want to prolong?
yeah, let's see. Some of your questions we may eventually get to with Logan, so why don't we hold them to the end? And then certainly both of us will be available to.
Write them down.
Yeah. Yeah, definitely write them down and say, yeah. Okay. So the next topic is, who are the parties? Now, first, everyone knows like this is gonna have a landlord and a tenant. As I mentioned, the landlord generally is a property owner. The landlord may contract with another business or another person to do the management of the property. So you may be dealing with the property management company. I mentioned that the landlord is required to make certain disclosures. And so we talked about those. So then let's talk about the tenant. In a commercial lease situation, there's actually a lot that's put on the tenant in terms of due diligence. So due diligence is the process that the tenant will undertake to assess the condition, the value, the fitness for use, and other qualitative aspects of the building where the tenant is looking to move in. So the matters investigated as a part of due diligence with which a tenant has to satisfy before execution of the lease, those are generally laid out in your letter of intent. So a lot of times your letter of intent, it will have, you know, the very basic, this is the premises, this is the length of the lease, this is the cost, you know, the money involved. These are the contingencies for entering into the lease. And then there's a list of things that the tenant wants to confirm before actually entering into the lease. So a couple of things to point out or to be considered as part of due diligence is the tenant's intended use of the premises permitted by the certificate of occupancy and relative relevant zoning laws and ordinances. Can you operate the kind of business you want to operate in this space? If not, will it be difficult to obtain any modifications that are necessary or any permits or variances that may be necessary? Is the location appropriate for your business? Are you going to be successful there? Well, this is an issue that usually comes up more for like a retail or a restaurant. Office tenants should also take that into consideration, whether the location is going to suit your business needs. Do the rights of other tenants affect the prospective tenants' use of the space? So if this is a shared building, you're only going to occupy a part of it. Who else is in the building? What other rights do they have? Are there common areas? And is that going to affect the business you want to do? I mean, if you're operating, you know, you have a business where you're operating, you know, a meditation room, and next door is a dance studio, that might be a problem, depending on the construction of the building. There are a couple of other people, though, that need to be considered in commercial lease situations. The first one is a lender, and this usually is the landlord's lender. So generally, if there's a mortgage on the property, the lender has an interest in making sure that the tenants and the rent payments are at a particular level. You know, what are the terms of the lease? Because that rental income is important to the lender to make sure that their loan gets paid. It's also of interest and importance to the tenant to know who else has an interest in the property, because again, remember, the lease is property interest. It's a right to possess whatever that lease space is. The loan documents that exist between the landlord and the lender often will have provisions, requirements, or restrictions for what a landlord can enter into with regard to a lease with tenants. And so whether you're entering into a new lease or you're looking to negotiate an existing one or modify it in some way, it's important to remember those loan documents and keep those lender requirements in mind. Lastly, we have a guarantor. And usually that's on the tenant side. If it's a brand new business, either the landlord or the lender may require the tenant have a guarantor sign off on the lease so that if the tenant defaults, they have someone else that they can go to for recourse and payment under the terms of the lease. So with that, I'm going to turn it over to Logan, and she's going to get into even more of the general details.
Hopefully I can figure this out also. And I will say to Sarah's point about the guarantors, especially when we do incorporations, whether it be LLC or C Corp, S Corp, whatever you actually need the guarantor, because you think of it even as a line of credit. The business itself doesn't have credit yet. So if they're going to enter into a lease, it's very likely that they're going to ask for a personal guarantee. Negotiable, but very likely. Okay, here we go. So this list is not going to be exhaustive. It's the what do you pay and the when. So this is timing and money. Of course, this is something that a lot of our clients want to know, right? What do I have to pay and when do I have to pay? And these are going to be factors that we might go over with each of them. So again, list is not exhaustive, but we're gonna outline a few of them. So with base unit, everyone will think of what do I pay as rent, but with base rent, you can't really see a rental price number without really understanding what goes into that particular number and how it's going to increase over time. So that's annual increases. So there are, as Tara mentioned, tenant rights when it comes to residential leases, like the Tenant Protection Act, but that does not apply to commercial leases. So landlords are free, if it's not specified in the lease, that landlords are free to make large increases if they need to. Obviously, that's a cost of doing business, and I would caution them not to, get themselves out of the market. But for tenants too, and landlords, you want to specify how much that rental percentage increase is going to be over time. This can also be county related to some counties, like LA County, I know, do have a cap on commercial leases. They have a very strict amount of laws when it comes to rent, but I don't believe that actually applies to Monterey County. So then we get into kind of not just the base rent, but also what type of lease are we looking at? There are different types, again, not exhaustive, but a gross lease is kind of the most basic form that we think of. So it's the simplest form where all the operating expenses for a building are included in the monthly base rent. So the landlord's going to absorb any of those operating expenses that might exceed that. I personally don't see a lot of just basic gross lease, but maybe a combination where a type of gross lease also might be the base rent plus a tenant in a building will have a percentage of the operating expenses that are split amongst all of the tenants. Sometimes it's just a flat percentage. Sometimes it's based on use, where I've seen in like a large shopping mall where it really depends on the usage. So they're going to look at meters, they're going to look at water, something like that, and then divvy up per month. It's a lot of calculations for them, or some of them might be like, okay, you occupy a certain square footage of this entire space, therefore you have X percentage of the utilities on top of it. But I'd say the most common that I see is net leases, specifically triple net leases, which is N also. So what triple nets are the operating expenses are not included and they're usually designated as additional rent. So there can be single, there can be double, but typically it's triple. And that's where the tenant is going to pay taxes, and I mean real property taxes that are attributable to the owner. Insurance, utilities, and also common area expenses, which are CAMs, which we'll also get into. So you have to think now, so you're gonna have a base rent with rental increases. And then deep down in sometimes in the lease, there's also gonna be provisions where quarterly they're gonna send you a bill for property taxes, along with common area expenses, along with you having to have some kind of insurance. So now that base rent is not the number that you actually thought of, or from a landlord's perspective, depending on the business, how are you going to offshoot those operating costs on and shift them onto the tenants while still being able to have tenants that occupy that space? Okay, so next up is insurance. I would be flabbergasted to see a lease that didn't have an insurance provision. Usually it will require tenants to have casualty as well as liability insurance. Usually it'll be it'll be a straight number or a multiplier. Sometimes it's like, 2 million for casualty, or 4 million, and it's usually double the amount. Some type of, it'll specify exactly what the insurance should be. So, and then typically the landlord will also be the person that needs to be added as an additional insured party, and then will require a certificate of coverage from your insurance to be able to present them to show that they are actually additionally insured. I think you and I joke too that it's all about money and liability when it comes to leases. So insurance is going to be a big component of that. Make sure I actually hit all of mine. Oh, and then of course, something to think about, of course, use qualified insurance providers if you can, and look into business interruption insurance as well as replacement of items. It just really depends on the cost, of course, but I've seen, clients come or things have been stolen, and if they have business interruption insurance as well as replacement items, then they're not, it's not going to be a scary situation as it can be without it. Then we have CAMs. So these are, like I said, common area issues where if you're having like any of these actually lovely like malls where they have different tenants, you're going to have common areas in between them. Sometimes it's entryways, sometimes it's parking lots, but they're going to basically be for your visitors or your customers to also use. Sometimes it's additional bathrooms, security as well that the landlord's hiring, but it's going to offset onto the actual tenants based on, like I said, it could be a percentage. So typically though, this is a landlord's obligations to maintain these common areas. So they have to actually do the work, but the lease will specify who pays for it. Sometimes it's the landlord, sometimes it's the tenant. And then we get into utilities. I know that's kind of self-explanatory. Heat, water, PG&E, even if you need additional security, depending on the business. Trash, etc., will be specified on, but more importantly, who's responsible for it. And those little details, it can make a difference of just seeing whether it's landlord, tenant, lessee, or lessor, which can be a little bit confusing. Okay. So when does the lease start and stop? As Tara mentioned, that's a lease term. Sometimes it's referred to a period, but it's, again, the timeline. When do the rights and tenants' rights of the premises start, and the obligations of the tenant start as well? And when do they start? We'll get into the how to get out of it. So, I mean, that's kind of self-explanatory. Commercial leases tend to be a lot longer, just depending on what the nature of the business is. So, and then you can get even into something like ad leases, which are significantly larger just based on maybe what particular group is going to be grown. But when it comes to commercial leases, usually it's in the 5 to 10 year range, I would say. But again, depends on the business. Another thing that we also look into is additional term options. This is a tenant right that we tend to build in there, and it's actually has a benefit for the landlord because it makes sure that there's longevity of this particular, there's not a lot of turnover in a particular space. But this allows the tenant to have an option to basically renew for a certain amount of time. So the example I have is basically you have a lease that's 10 years and you have a single option for an additional 5 years. So maybe within a specified time before the termination of the lease, you can say, hey, landlord, or the landlord will get a notice from the tenant that you want to renew for the additional option. A lot of the time, those options will also specify how much the rental increase or how much the rental increase is going to go throughout that option time if they want to. Again, you can do it or not do it. Okay, right of first refusal and rights of first offer that kind of go hand in hand. They're a little different, just slightly. So basically, this gives the tenants rights within their leases to have, say, you rent a space and you want the one next door to expand your business. You can write in to the lease that you have either one of these two, right of first refusal, rights of first offer. The right of first refusal is when the landlord receives a third-party offer to lease the space because it becomes vacant, and the landlord must first offer the vacant space to the tenant under the same terms and conditions as that offer. Okay, now the rights of first offer in a lease are when it's they already have an occupant, or excuse me, they have a vacancy and they offer it to the tenant under the same terms and conditions as your lease, the tenant's lease. So that same lease will then expand to those premises as well. So it's the difference of them getting the offer, and you're going to have basically two leases. Essentially, if you want to, you have that first option to say, I either do want to lease the space or don't, before they can offer it to an outside party. Or the other option is that it becomes vacant and they have to offer it to you before they go out and try to seek third party offers. So the wheres, the space and its uses. Really the question becomes, does the space work for your business, and what is required to make the space work for your business? So build outs and alterations are extremely fact driven. If a space, if you want to operate a restaurant and there is no kitchen, that's going to require a lot to get that space up to code, up to where you'd be putting in a walk-in refrigerator, or FRP, or the hoods, or that would require a lot of construction. So will that construction be required? Does the landlord need to consent to that construction? Whose cost? Is it on the landlord's cost or the tenant's cost? Will there be a rent abatement if there's any disruption or it goes longer? Are they just simply alterations that are cosmetic that may not require the landlord's consent? Are signs allowed outside of the business? Actually, with the sign thing, the lease might say, specify whether they are or not, or the landlord has to give consent to the design, because if you don't want it to be, flashy neon or something like that. But local rules also specify whether or not signs in particular areas are allowed. So it might not just be the landlord, it might be fighting a little bit with the city on what's allowed to. Permitted uses, the lease will explain what the premises are to be used for and what the landlord gives reasonable consent to, but you cannot use the space for anything other than what is permitted, or that will be seen as a default on the lease. So if you wanted to expand, or if you wanted to add, you likely need to get consent, and of course, you would always recommend it be in writing. Repairs and maintenance, typically, I've kind of touched on this a little bit, but typical to have a landlord maintain and repair the structure of the building and those common areas. But again, think of the triple net and the cams that might come back and make everyone very sleepy. But if they are obligated to make these repairs and maintenance, remember that they could be putting that cost onto the tenants. But at a baseline, they should be, if a pipe bursts, it's usually something that's on the landlord to fix. ADA compliance, again, very, very specific. Of course, it depends. We like to have it in the leases, of course, written out, because everyone says that they get along until they don't, and then they bring out the document to have to point to a certain situation. So ADA compliance, both landlord and tenant are responsible at the base. But you want to make sure to specify who, in those cases, if they get red tagged or something like that, actually has to bring the building into compliance. Okay, how will the lease end? There's a few different ways, and one I will mention, but it's not listed on here. So, lease term, it's coming to an end, and you decide not to do an option, so it's time to move out. What does the lease require for you to move out? What does it say about fixtures? And that's a legal term of art that, I mean, I can typically define it as something that is movable or not movable, or that you would have to do damage to the structure of the building in order to remove. I use a walk-in refrigerator as an example, because that is now part of the structure of the actual building. That becomes a fixture, that becomes a part of the property. You can't take it with you. So rather than something that might be a movable refrigerator, is different because you can actually unplug it and move it out. So what required when it comes to fixtures. But beware of language, these kind of difference between the two: restore to original condition versus reasonable wear and tear. Or I've seen broom swept condition. One allows for, of course, reasonable wear and tear on a business, and the other one would require a lot more repair. And of course, remember your security deposit, right? I use the new carpet. If you have new carpeting into your lease space, and it's restored to original condition, that can be interpreted as you have to replace the carpet, versus having reasonable wear and tear is you use it and maybe you have, at most, you have to get it cleaned or you vacuum it or something like that. That's a huge difference in pricing, especially coming out of a security deposit. Now, holdover tenants. This is when you move out late, maybe past that certain date that you have to be out by 5 p.m. on the 30th. And it's technically a violation or a default, which we'll get into. And it depends on the lease, but there could be hefty penalties if you have even a day over. It could be an entire month. It could be an entire new lease. It really depends on the situation. Now, a default, this is a violation of the lease. Examples: fail to pay rent, you assign the lease without approval, failure to repair, you abandon the space. Some leases that I like, if we'll say I'm representing actually either party, that you have a cure period. So this is usually a small amount of time to fix the problem and not be considered in the default. So if you fail to make rent, there might be a late penalty, but you still are not considered to have put the lease in default, and therefore the landlord or the tenant can terminate the lease for whatever the violation might be. Or you fail to make a repair, you'll have 30 days or something like that. So you have an opportunity at least to fix the problem, and it gives you a little bit of breathing room. Of course, there are acceleration and default rate penalties. Again, if I'm representing the landlord, I want to make sure that these are in here. And they, of course, baseline breach of contract, they can get you for that. But acceleration of the entire rental amount, say you default in the first year of the 5-year term, and they could accelerate the entirety of the amount you would owe, what they would lose through that entire 5 years. Or possibly a default rate where it says you have to pay 200% penalty fees or something like that. Or if there's, 15%, it's varies. It can so vary, but it can be the difference of that's what an acceleration or a default rate actually are. So you can see the cost prohibitiveness of ending a lease and negotiate, or even negotiating an end of a lease if parties fall out versus just straight defaulting and having violations. I think that's all I know. Here. Okay, do you want to do questions? I know I just threw so much stuff.
Can you talk about the grant for, when you said personal grantors, are you talking about, like, me as a receipt?
Yes, yeah, so, I'll use Google as an example. If Google wants to enter into a lease, it's a company. It needs a person to actually go to hold personally responsible. So if you have a business and you incorporate that business can be sued as a business, but it doesn't have any assets to sue, so the likelihood of getting their money back is very little. But say a person starts a business and they own their home. Now they're gonna want a personal guarantee, so they can basically go through the corporation and also hold you responsible. So they'd sue the business and you personally and be able to access those assets. Yeah.
And to add another layer to that, a lot of times that guarantee will be a secured guarantee. So not only do they want you to sign saying, yes, I will be personally responsible, they're gonna want you to put your real property, your home, whatever asset you have, and put a deed of trust on it, so they have a lien against that, securing your guarantee.
Yeah, or even seen, they'll secure a UCC1 against all the assets of your business, all accounts receivable, all your equipment, everything like that. So I've seen variations, both are just a simple personal guarantee.
There are many ways that, I mean, obviously, I know there are, straightforward ways to protect your personal assets from, obviously, you're gonna be guaranteeing another person for your own business, but to protect that in some way or another, it's done at a big level, but maybe.
Yeah, usually corporation is the way to go about that, to incorporate, and then, right, you're already incorporated, so they want your personal business. I would say, again, specific, maybe you can do that too. I would say that probably signing the personal guarantee was what I would recommend, and then later on down the line, when the business has been established, removing that language or having something in there that it can be removed after a certain amount of time.
Yeah, I mean, there's always the possibility too, that if the terms, if you are a prospective tenant, the landlord of the space that you're looking at has terms you don't feel comfortable with,
Yeah,
shop around.
yeah, it's not your only option.
It's not your only option. There may be another space that will work just as well or better, and is willing to negotiate some of those things that you're most uncomfortable about. So never feel like, as a tenant, that you have absolutely no choices. And so going back to what I was saying before, part of why in commercial lease situations, the law doesn't provide some of those implied warranties is because the law assumes that the parties are in a little bit more balanced or equal negotiating power. So if a landlord presents the form of lease to you, don't ever feel that you just have to accept all those terms as it's laid out and sign it. There's always room for negotiation and for shopping in different spaces.
Yeah, and to say that, oh, well, this is the one that all the tenants are doing is not necessarily an instance either. There's still, might not be as much room for negotiation, but there's still room for negotiation.
Yes.
I have a question, because I know there's a commercial where they have a gross lease. And after going to the building, the way it's designed, the breaker box is in somebody else's lease space. So they've had recurring issues. I can't name the building or gift, but and it sounds like a sweet deal, because in Monterey County, when we look at a lot of these triple net, really high prices because of the location. But in a situation like that, because I noticed we talk about default more on the tenant side, on the landlord side, if there's recurring issues where they're not meeting, and I know particular landlord is living in Southern California and is not responding, they're just like virtual. How do you handle a situation like that? Because now you can't operate as a business, and I get it about business insurance, but you're kind of like caught between a vine, you know, a rock and a hard place. So that's my first question regarding landlord. And the second question I had is regarding TI. We talked about tenant improvements. I noticed that usually that's the landlord who pays for that and has the obligation to deliver the space according to those terms. Is it correct?
I'll do your second question first. Great, it depends, yay. It depends on the agreement amongst the parties, who's responsible. I've seen both. So it really depends on what the landlord's willing to do. Did construction or improvements need to happen prior to the space and they're solely responsible for that to get the tenant in the space? Or was it something that is the lease saying, okay, if you do improvements, you're more than welcome to, but now they've become a part of it and you're solely responsible. So it really depends on what the lease says. With the first question, the answer is there's rights available, especially in that situation. Again, very much going to be dependent on what the four corners of the document say. But again, crystal ball here or like petri dish. Yes, there is options for the tenant depending on what their goals are, and that would be something I would talk to them about. Do they want to get out of the lease, or do they want the landlord to perform? Which one is going to go to two very different avenues?
Well, that's kind of like the difficult part of it, especially if you have a breaker box and someone else leaves space. And that's like the security of that, trying to, you know, go into that. It impacts that other lease space.
Yes.
But I think the big thing, I'm in the residential real estate with business as well. I noticed with disclosures, for example, it's all up to the buyer, it's like buyer beware, especially when you're doing your due diligence with disclosures. So that's what I was wondering about on the commercial side, because you signed it and there, I don't know if they have the same due diligence period where you have to review everything. And you know, by doing, I don't know if you do the same inspections like you do on the residential side, because as soon as you sign it, and when I noticed in California, it's different than other states, somebody could have something that's illegal, unpermitted, and they, as long as they disclose, the buyer knows that and they sign it, it's on them, the liability. So is that the same on the commercial side that, you know, let's say the landlord did like fail to disclose or so again, it's the whole liability piece.
Yeah, so landlord disclosures are, you know, in a lease situation for commercial leases, it's pretty limited. I mean, the two disclosures I mentioned. That's why it's so important the tenants do the due diligence to make sure the space is going to work for them. In this situation you're talking about, again, you know, as we said at the outset, there's only so much that we're able to provide general, you know, information about. It's really going to depend on what's in that particular tenant's lease agreement and what they're looking to do in their situation. Whether, as Logan said, do they want to terminate? Do they want to try and modify their existing lease to resolve this situation? Does the existing lease already have provisions in it for this utility? I'm assuming, since you mentioned Baker Box, it's electricity and provision of electricity to premises. So it's really going to depend on what's in their lease in order to be able to advise them what their next steps and options may be.
Yeah, I've seen some where it's, if, you know, with reasonable notice to the landlord and they fail to fix the issue within a certain amount of time, then it's the option of the tenant to terminate. Or, and I've seen ones that are completely silent. So it really is going to depend, like, on that situation. And in my head, I'm thinking, okay, you said failure to disclose. That's another, you know, hot button topic or red flag for us. And do they want to just negotiate, or do they want to go to the court? It's really going to depend on that.
That makes sense. A lot of it, like you said, you could just Google information. Particularly
Beware.
Beware.
And legal doom, please. Legal doom.
I will say, I mean, we talked about Googling and AI. We can tell you a number of cases that have gone to court where attorneys in other jurisdictions have used Google or AI for their legal documents, and it is completely wrong. And they have been sanctioned for it. So beware of Google and AI for your legal advice.
We have tested it. I got on ChatGPT knowing like a corporation, California Corporation Code section, knowing what it is because it would eat into my brain. And I'll ask it and it will give me something completely wrong. So definitely beware of that too. And blanket documents, because I don't really like the term boilerplate. I like the term Frankenstein, because most of the documents that we use can be a Frankenstein of many different things to craft and create for every client's specific needs and situation. And who we're dealing with too is a big picture. Who are the parties we're dealing with? And what is their relationship? Do they, between them?
I mean, one of the things that Logan and I, as we were talking and considering this presentation to you all, is because there are so many different tax specific things that come up in negotiating leases. Logan mentioned ag leases. You've got office office leases, retail space, shopping center, restaurants. The list goes on, and what the landlords and tenants in each of those businesses and types of situations is going to be looking for, and that's important to them, is going to be dramatically different.
Yeah. And what our clients need, who hires us, and how we can help them. Is their goal to save money or to limit liability? Because those aren't necessarily the same thing. Or sometimes, we can do both, but it really depends on the situation.
I just,
You're going to go to here and here.
so when you have that's multi-use,
Yeah.
so commercial mixed with residential,
Mm-hmm.
and there's a mixture for different meters, water meters, electrical meters, etc. Can you basically come up with a lease agreement that is legal enough, since there's not separate meters, that allows you to share a portion of, like you've mentioned?
Yeah.
Sometimes you look at CAMs and saying, okay, you have 2/3 of the property, they have 1/3. Is that something that is possible, even though there's not true separated
Yeah.
metering of any utility?
I've seen that usually, and again, generally, but yes, absolutely.
Okay.
Absolutely is. And I'd like to say it's usually percentages on use. I've seen.
Residential doesn't really care about how much they use.
No,
Because
but
they're-
I'm in my head, I'm thinking, okay, what is high use restaurant with a house next to it, right? Huge difference when you're washing dishes or have maybe, like, it really depends on the situation. It's an entirely different use than the residential. So
And
there
with
is
the
a
same
way.
Use scenario, if you sign a lease with someone that is for a particular use that's within the zone, and that during that portion of the lease, within 3 to 5 years or something, they decide to change the usage on the property, is it something that has to be disclosed, it just has to be written into the lease?
You mean like
we-
zoning?
So the zone is there, they are, growing pot, for instance, in the warehouse, now they decided they're gonna go ahead and bake goods. Do they have to disclose that to me as the landlord? Or is that something that?
Wow, so it's fact specific. I also have done cannabis law.
No, okay.
Yeah,
Let me
but
go.
so
It was just a quick and easy one.
like, yeah. That is.
That's a different one.
Oh, like with the level of laws that just like clicked into place in my head is so extensive.
How about?
Yeah.
It was retail of some sort and now becomes a bakery and it's no longer. So if they've written a lease with me as the landlord, do I have the right to understand that? Not so much the inspection of premise, but can I say to them, hey guys, before you make this change, you have
Yes.
to let me know. And
Again,
it can be written in that way,
we'll
right?
say written in, what is written in currently.
Yeah.
And what does the permitted use say? That is something, and whether or not require disclosures or not, I would typically say, if it just tells straight up what the permitted use is and it falls outside of that, then they're gonna get into some home.
I mean, generally, a tenant wants the permitted use provision to be broad enough that if they decide to diversify slightly and it's
Right.
related to their business that already exists,
Issue.
that they're gonna be okay. But the situation you're talking about where they were a retail store, now they're gonna become a bakery. I mean, I'm thinking, okay, you've just gone from selling, shirts and pants possibly to now you're installing, ovens and things, your liability is totally different.
Yeah, I'm thinking too, parking issues, the amount of people, like there's a lot of factors.
So, not to mention the prospective income,
Yeah,
that's coming in. You negotiated the lease expecting it to be a retail store with retail income. Now they're switching it to something totally different. Yeah, absolutely. So usually the landlord wants the usage provision to be as tight as possible to allow for those types of situations they have to disclose. if they're changing. Right, but a tenant will want it loosened up a little bit so they have the ability to diversify or expand out maybe into another related branch that relates to their existing business.
and there's a way to meet in the middle for both parties to say, here's,
Okay,
yeah,
yeah.
like here's a specific permitted use, but if you want to expand, you need reasonable. consent, something like that. But it's, yes, it's possible to build that in.
Anything is possible to build into any.
Anything is possible, as long as it's not like.
Yeah, and that's, I
Yeah,
think,
yeah.
that's why we hire someone like you guys, is to kind of keep us open for.
Yes, yeah, and again, to meet your goals or the goals of the parties, and that really is. And I say that not just from a monetary standpoint, but an emotional standpoint. A lot of what we do can, I mean, we're not therapists, but you know, I can't tell you how many people are like, to go for, something on principle has a monetary value to that, but also has like an emotional toll. So you have to, another part of it with who you're getting into business with, you're gonna be in business with them for a long time. So if they're already at the initial, like this gut wrenching and you don't, and just difficult to deal with, you're gonna be dealing with that a long time through. So that's something to consider, the emotional aspect of it too.
And there's no such thing as squatters' rights in a commercial lease, right?
Well, there's holdover tenancy,
That's what you said,
right,
yeah.
not like that, no.
Okay.
Yeah, again, residential, commercial.
Two different things.
Yes, a similar question.
Yeah.
For the like overpopulation in Monterey County.
Yeah,
Seeing a lot in Houston, in real estate industry about mixed use where they're taking an narrative in Cornell or the other state. But having commercial on the bottom and then residential.
Mhm.
Is that something you're hearing or
yes,
you are okay? And
Yeah.
Is that can be part like a requirement at a certain portion, like, and not only that, but also certain multi-use buildings, a certain portion being rent controlled all of a sudden, like that's a big hearing. 20%. I've seen it in my conversations at New York City decades ago that was required, and the luxury like buildings they get like that because of the sudden that I don't want to get into that if it just gets too messy, but regarding the mixed use, like what would you recommend? Is that something more? I know it's probably better to consult the right subject matter expert. If it's legal or if it's more on the room for any religious, yes.
or policy. That's another thing too, that, you're talking about, I mean, you look at Section 8 housing. If you don't have it, then you might be able to pay a fee towards the business. I don't know of a bright line rule. I think that it's something that they're trying to, again, personal opinion, not any type of legal, that I would see them trying to incentivize, because to try to kill two birds with one stone. I don't know of any requirement, but I could see it incentivizing particular business owners or owners to do that. When it comes, yes, have we dealt with those? Yes, of course. But again, we're talking about residential space, commercial space, two different leases. Too.
Oh.
Yeah. And of course, where does that overlap? I don't want to look at your, is the breaker in a commercial space or something like that, so.
Well, it's also the fact that, let's say you have now a residential tenant who's throwing these crazy parties, now there's noise impacts
Yeah,
to the business.
or vice versa.
Or yeah, that too, like but again, it's one of those things like you said, it's reviewing the sign.
Yeah, now you're talking about noise ordinances or particular zoning areas, there's a lot of factors to that, so it's the where, what, when of the situation. Yeah. I know you had a question too?
Yeah, so understand the number of small businesses over in this area. Most of them do. But there are occasions where folks have leases or some kind of money. What happens when a new owner comes in and there is an existing lease or there's a month to month and now there's rules with two businesses that are already established within that person time? Is there protection on either on the lease one or on the month to month one?
Go ahead and start.
Okay.
I've got thoughts, but
Yeah, oh my God, I got so many thoughts. So I'm gonna always be aware of a month to month in that commercial aspect. Wow, is that risky? So risky.
Probably 80% of businesses when you sell this are like that.
Yeah, I would, well, yeah, and I get it, you don't know, you kind of wanna try things out, but. So the answer is the landlord can pretty much do what they want, in a month to month situation, because you're basically new lease, new month, right? So you're not holding their feet to any fire. So if it transfers, those rights transfer as well. And now they can do what they want with it. So it's not necessarily, yeah, I've seen scoffle certificates in, commercial leases that tenants might require. And what that means is that a landlord, if they decide to sell, are stopped from basically, like, they have to take it over, essentially, under the same lease terms. And they'll make sure that that's a part of the negotiations. So I'd say, let's get them into leases if we can, but that holds tenants' obligations as well. But right now, you're doing a cost benefit analysis, and that's a lot of what we do. For depends on the people, what's their situation, what's their business. But yeah, I would stay so far away from month to month.
now someone who is in an actual written lease or a lease for a period of time. So as Logan mentioned, month to month, that means the term is 1 month.
30 days
That's it.
starts.
And so you're kind of renegotiating or renewing that lease every month. When you're in a longer term though, then the tenant does have protections for that longer term because they have a property interest in those premises for that term. So there are more protections potentially and very likely for a tenant in that situation, which is why I would certainly echo Logan's encouragement of, do the cost benefit analysis. If you're doing well enough as a business, definitely look at having some of those other protections of a longer term through the formal negotiated lease put into place.
And that's an asset to the business, the leases. It has a dollar value to it. So if they ever want to sell, I've done business escrows a lot, and besides FF and I's, it's the lease has a number attached to it for a price. So especially a longer term lease is going to have a lot of benefit at the end of wanting to sell.
Under situations like that, if it's month to month, it's more of a rework environment might work better for those sort of businesses where it's a license versus a lease and might make better sense for them. When you have CAMs connected to a lease, do you have to disclose the CAMs to your the person that's renting from you if you're the landlord?
It's not a required disclosure, but
It's not.
not to my knowledge.
You
that
don't
you
have to show proof
specify.
why you're paying X amount
Should.
of property taxes.
You should. I'll think longevity if someone ever sues a landlord for that particular issue and evidence that the landlord showed or was reasonable in that situation. So I would put that in, that they are not going to be unreasonable and decide that they just did the parking lot and now a year later they're going to repave it and put it on the tenants or something like that. But it would have to be that word, that reasonable word, that reasonable improvements, reasonable maintenance, or it's specifically what they're going to be required to pay and how much of it.
And if you're paying CAMs as a person that's used to the property, can you tell them, hey, the maintenance that I'm paying for is crappy. You guys need to do something better. I'm paying $400 a month for this. Can you kind of have a little bit of say in something like that when you're paying for it versus not paying for it?
Yes, but it depends.
It's always about.
It depends on what's in the lease. And this is why so much of, so I, you know, we both do negotiations of leases at the outset, and so much of what we do is thinking about all the things that can go wrong.
Captain disaster,
Yeah. And
another captain. disaster.
so, and, you know, in addition to, you know, the corporate work and the transactional work I do a lot of litigation as well. And so I see on the other end, all the things that have gone wrong. And so one of the things that we would be talking about with our clients is, okay, you have this, you know, you're gonna be paying CAMs, but does the landlord have to provide documentation or support? You know, if there has to be a billing statement that's issued. What is it you're going to ask of the landlord before you're obligated to make that payment? And that's all things that can be negotiated in the lease, and it's much more cost effective to do that in the beginning than to try and sue them
Yeah.
for it later.
And that's what, how specific do you wanna be? What do you wanna hold them to? And, or hold yourself to as well. And I've seen ones where it's just like, okay, here's the base rent and here's what is roughly the approximate of what CAMs are. And they'll say it's $800 or something like that. And again, that goes ebbs and flows depending on what the landlord ends up paying.
The insurance situation in California, we're seeing a huge increase in one of the buildings we rent. And they're passing that increase from 3,000 a year to 18,000 a year.
Yeah,
Onto the people renting.
yeah, yeah,
And legitimately, it doesn't seem like that's right. You know, it's like,
yeah.
wait a second.
That's a hard thing too. Sorry, I know that's kind of, I know about that, but so many have pulled out. So many companies have pulled out of California, so you have so little amount to actually make sure that there is insurance, because to not have it is almost, you know, a kiss of death in some situations. So yes, you're almost bet your bottom dollar that if there's gonna be increased costs to landlords, there's gonna be increased costs to tenants.
And they're,
You know, so yeah, sorry.
I'll ask one closing question.
Yeah.
So for someone who's gonna be a tenant, who's the best person to negotiate your lease for them? Is it gonna be the real estate commercial broker, or is it gonna be an attorney? And at what point do you bring an attorney?
Excellent question. Yeah, and I'm gonna go back to, it depends.
We have so many referrals from
We do,
realtors.
we do.
We really do.
We do. Definitely, you know, I've had clients that they want me in the negotiation from the beginning. I have other clients that are like, we're pretty much done negotiating. Would you just please look this over for anything we may have missed? So, I mean, it really depends on the business. It depends on the space. It depends on how comfortable the tenant feels
Absolutely.
in, you know, kind of looking out for their own rights and interests, and, you know, what's important to them and how comfortable they are with their own negotiation skills. So
Yeah, are they dealing with a crazy landlord, but they really want this space, so they have to bring in a little bit of strong arming to, you know, have the letterhead on it to make them feel more comfortable. It really, again, great. It depends. It was our worst, my least favorite phrase in school, so I'm sorry to push that on you guys as well.
there's potential savings in, you know, doing more of it yourself. And
Yeah.
we understand that, we recognize that.
Yeah.
On the other hand, I'm sure, Logan, you've had this situation where a client has brought me in at the last minute and I've looked at the document and it felt like it really just needed a rewrite. And it would have been better if they brought me in early.
Yeah, way more
So-
cost effective too, even from your hourly fees, right? To have it at the beginning when they have an LOI and we can kind of negotiate terms and maybe just draft something ourselves, or even using car forms. Are a great alternative too, but again, it depends.
as an attorney, can you represent both the leaser, the lessor and the leasee, or that's against the state of California law?
Well, okay, can we represent them? No, but can we draft the documentation and more or less be a glorified secretary? Yes, with the proper disclosures, yes, I've done that also. When everyone's kind of getting along, then, but if there's any type of negotiation or dispute about a clause, I throw my hands up, that's not for me. So delicate situation, but it can be done.
Usually what would happen is we would represent one party or the other and tell the other party, you are free, and we in fact recommend that you seek independent counsel. It's not required. And then as Logan said, if there does become a dispute between the two, sometimes then that will force us to have to withdraw completely.
Yeah, which we try to avoid if we can, but again, certain situations where I've had both maybe two clients that I know very well, they've done their own due diligence, they're very savvy and might, step in the situation. Yeah. Great. Thank you, guys.
Thank you.
very much.
Okay.
Thank you for calls for our guests. Thank you guys for joining us today for our workshop. Here's our contact information. If you guys have any questions, we will be sharing today's slides and a recording of today's presentation. So keep an eye out for it in the email that you used to register for today's workshop. And again, as you've mentioned, all of my services are completely free if you need a little bit of technical assistance. I could do that, and we'll also be sharing the contact information.
And I brought business cards as well for my focus, if anyone needs
Thank you.
those to work.